Good afternoon, Instagram. Good afternoon, YouTube. Hi, everybody. How we doing today? What a great week we had last week, and what a better week we're going to have this week. So we're going to dive right in here, and we're gonna flip the page here. We're going to twist it around. We always talk about what we could do to make our case worth more, but we're going to talk about why your workers' compensation case might be worth less than you think. We're going to clear up some of those misconceptions that some people have about their case and the case value, and we're going to jump right into that right now. Thank you for joining. You guys did a great job last week with your wonderful questions. Looking forward to more of the same this week. I see them pouring in already. So most injured workers are shocked sometimes when they see how little their case is really worth. And it's not because they did anything wrong. It's simply because the rules of workers' compensation are not always in your favor. There are certain aspects that are working against you. And certain things that you think might be worth money are just simply not worth money. If you don't understand what these limitations are and what these rules are, you could be counting on money that's really never going to show up in your pocket. So today we're going to break down the biggest reasons your workers' compensation case might be worth less than you expect and what you need to know to protect yourself from getting blindsided by this. Again, we just want to talk about misconceptions and why. We always talk about managing expectations, and that's really the most important thing. We hear it all the time. People say, well, the carriers offer me $20,000, but I owe $30,000 in back rent and credit card bills. That might be true. That really doesn't even, it's completely not applicable under the workers' compensation law. It might be horrible, and it might be a very sympathetic story, but a judge is not going to want to hear it because there's no value in that. There's nothing in the law that allows you to be compensated for past due rent and bills. Past due child support is another thing. It might be a terrible story that you're behind on child support, and it's going to come out of your workers' compensation settlement, but it doesn't mean they're going to give you more money. Rex for president on Instagram. Thank you. Maybe one day this movement will gain some more steam. Miss B is going to collect those likes for me, and we'll get momentum here, and that'll be it. And you guys will be in my cabinet. Another thing people always say, the rent thing is big. Pain and suffering. Excuse me, I have a little chest cold. Pain and suffering. Well, what about the money for my pain and suffering? I'm in so much pain. I can't lift up my kid like I used to. I can't play soccer like I used to. We hear that all the time. And you know something? As horrible as it might be, and as sympathetic as it might make your story, there's no value in pain and suffering under New York State workers' compensation law. Punitive damages. That son of a bitch, he knew that forklift was broken, and he knew that the floor was slippery, and he knew the handrail was broken, and he knew the chair he gave me was broken. And there should be punitive damages for what my employer put me through. And while it sounds right, it's wrong. There's no punitive damages in workers' compensation here in New York State. So we're going to touch upon those factors here, those misconceptions. I'm already starting slurring. The misconceptions that people have with regard to their workers' compensation case and where the value lies. And we're going to discuss that today. Oops, I went too soon. So why might your workers' compensation case be worth less than you think? And like I said, pain and suffering, the number one, the biggest one, pain and suffering. There is no pain and suffering under the workers' compensation law. Most people expect that it's there. Personal injury cases, pain and suffering is compensable. It's worth money. In workers' compensation, it is worth $0. You could be in the worst pain ever, but if you're able to work, and that pain, I mean, we do ask the question, is pain disabling? We ask that question of the doctors all the time. And they concede that it is, but pain in and of itself is not a compensable aspect of your case. And unfortunately, the dollar value is not there. It's only worth money if that pain translates to a disability, an inability to work, a reduction in your earning capacity. That's when pain is valuable. But additional money on top of your case for pain and suffering, sorry, it's just not there. And with the suffering aspect of it, when you move away from the pain, because pain is pain. Pain from your injury is pain from your injury. The suffering aspect, I haven't been able to get I haven't left my house in 6 months because of this injury. My spouse left me because I'm down and I'm out and I'm not making money, and this horrible thing that happened to me, this horrible injury and accident, has caused me to get a divorce. those are unfortunately not compensable aspects of your claim. Some people understand it. Some people, I have to talk them off the ledge when we have this discussion about pain and suffering not being compensable. And here I am to hit you with the brutal truth. Pain and suffering equals $0 in your New York workers' compensation case. In your personal injury case, it is worth money. And the same, like we said just now, it holds true for punitive damages. I'm looking at my notes here. Do I? No. Punitive damages, no value. So what's a punitive damage? Punitive means punishment. So if you are driving to go pick up milk for your family and you're passing through an intersection and you have the green light and some guy is playing on his phone and he's not paying attention and he blasts through the red light on his side and he T-bones your car and he causes you to get hurt and you're going to sue him because this is a everyday motor vehicle accident. You're going to sue him for a lot of different things. You're going to sue him for your lost wages and your medical expenses and your pain and suffering, and you're going to sue for punitive damages. And what are punitive damages? Basically, after all said and done, and we figure out the dollar value of your claim and you get the money that you're entitled to, the court's going to impose an additional award, an additional damage to punish that other driver, to punish him for being such an idiot. And that's what a punitive damage is. So when somebody causes somebody else to have an injury, and that person who causes the injury is not your employer and not your coworker, it's somebody you can actually sue. And as we said before, we call these third-party cases. You're going to also sue them for punitive damages. And depending on the extent of their negligence, their indifference, their stupidity, their wanton recklessness, whatever the term is and the standard is, that's how much the court will impose a punitive damage on them. And that's a lot of times where the big money really comes in. Your lost wages are your lost wages. We could figure that out. You can have an economist come in and figure out how much you've lost because of this injury. And you can have them figure out what your future losses might be, considering all of your raises and all those things that they look at in a personal injury matter. They could figure out what your medical bills are going to be very easily. They add them up. They could figure out what your future medical is going to be by doing the same equation that they do when they do a Medicare set aside. Those numbers are fairly easy to calculate. And ultimately, are they worth a good amount of money? Sure they are. Are they worth the millions and millions and millions of dollars that you see on the cover of the New York Post every once in a while, or you read about, or you see on TV? No, those big numbers are pain and suffering and punitive damages. So if somebody's really negligent and really stupid and really causes a bad injury because they really weren't paying attention and it wouldn't have taken much care to prevent an injury from occurring, they're going to get slammed with a huge punitive damage award on top of everything else. And that's where those big numbers come in. When you look, you very rarely, almost never see in the news a huge workers' compensation settlement. You see those big numbers when it comes to the guy who fell off a ladder, the guy who fell off a scaffolding, the guy who was injured on a construction site, the motor vehicles. Those are the ones that have big third-party cases and thus the big punitive damage and the big pain and suffering awards, two things which are not compensable in New York State as part of your workers' compensation claim. But you shouldn't shy away from filing that claim, because workers' compensation is your exclusive remedy when you get hurt on the job here in New York State. So if you are working and you get hurt, first and foremost, the first thing you have to do is file a workers' compensation claim, whether you have a third-party case or not. And if you do have a third-party case and you are going to sue a negligent third party, the guy who ran the red light, the building, the property owner of the building that you fell at, whoever it might be, you better file a workers' compensation case, because workers' compensation benefits are first-party benefits, they call them. So before that lawsuit's going to be permitted to proceed down the road, they're going to want to make sure you file for workers' compensation and you're getting the benefits that you're entitled to under the workers' compensation law. It's confusing. There's a lot of moving parts. I'm sure me speaking at the speed I'm speaking is not making it any easier, and I apologize. I'm just fired up. Had about 18 cups of coffee today. But that's why it's important to have an attorney that knows what they're doing, and an attorney that works with the third-party attorney and the workers' comp attorney, so they work together so they get you the best outcome possible. And that's what we do here. If any of you guys need assistance, as you know, please give me a call, 212-406-8989. Victoria, last week, I know you were looking to speak to me. I didn't see your call. Did I miss you? Call me. What's another reason why your workers' compensation case might be worth less than you think? Well, we talked about average weekly wage. We've discussed it over and over, and we discussed what your rate of compensation is and how they calculate your rate of compensation based upon your average weekly wage. And what does that mean? At the end of the day, you don't get your full salary when you get hurt on the job. You get up to 2/3 of your salary. And for you super high wage earners, you cap out. So you might not even get that 2/3. Right now, the max rate is $1,222.42, according to the cheat sheet that I have scotch taped to my radiator. And that's the maximum rate. So what does that mean? 1,222.42. I should have done this math in advance. 1,222.42. That means, folks, if you earn $1,833.63 or more, you're going to cap out. Okay. So if you earn $1,833 and you have a total disability, you're just going to kiss that max rate and get the maximum amount. Excuse me. But if you earn $6,000 a week, if you're doing it, well, 2/3 of $6,000 is $4,000. You're not getting compensation at $4,000 a week. You're getting compensation at $1,222.42, which means if Bill Gates, Elon Musk, you name the guy, is working in New York and gets hurt and files a workers' compensation claim, they're going to cap out at $1,222.42 per week. That's the max rate. And that stinks because obviously that person earned a lot more, but sorry, that's the rules. Them's the rules. The only benefit that comes out of that is for super high wage earners, your cap can also hold true for partial disabilities. So if you earn enough money, you could still cap out with a 50% disability or a 70% disability, but you're still not earning what you were earning before, which is a shitload of money that you're losing. So workers' compensation only compensates you 2/3, up to 2/3 of your average weekly wage, up to that statutory maximum. Now, there's two things that work to your benefit here, so it's not all sour grapes. Number one, we base it off your gross salary, not your net salary. So if you're netting, it doesn't matter. It's your gross salary. It's your pre-tax salary that your average weekly wage is based off of, not your post-tax or net salary. So that gives you a little bit of a bump. And number two, workers' compensation benefits are, who wants to say it? Who wants to say it? Who wants to say it? Tax-free. Workers' comp benefits are tax-free. So your benefits are based upon your pre-tax numbers, and your resulting awards are not taxed. So that gives you a little bit of breathing room, but still you're not getting the amount of money that you were getting when you were injured. Miss B is on it. She's going to crack the whip. What other reasons might your case be worth less? And again, I'm not telling you these things to bring you guys down and to hurt your feelings and to squash your hopes and dreams. It's like we always say, we're managing your expectations, and it's an important thing, because some people, they come in and they say, my case is worth $100,000. Well, and when people come to me and they pitch these big numbers, or these numbers that are relative, 100 might be worth, it might be low in certain cases, it is low in a lot of cases, but when people pitch numbers to me, I always ask them, where are you getting the number from? Oh, well, I got all this pain and suffering. Okay, well, let's start there. There's no pain and suffering. Well, I was earning $1,800 a week. I want that money back. Well, we don't use your full salary. We use 2/3 of your salary. So, before I even get into the nuts and bolts of how much a case is valued at, in speaking with a client, I want to know where their brain is at, because I want to manage their expectations to say, hey, pain and suffering is not going to happen. Your full salary is not going to happen. Punitive damage is not going to happen. What else is there? The cap. Dun, dun, dun. The vaunted nasty cap. What's the cap? For those non-scheduled cases that we discuss oh so often, your permanent partial disability cases, you are capped at how much money you get and how long you get it. And depending on how long your case has been going, for those cases, that have been dragging out for years and years and years, that cap might be subject to another hit. So, for instance, a 50% permanent partial disability gets you a maximum of 300 weeks of compensation. A 75% disability, a significant level of disability, gets you 400 weeks of compensation, maximum. 400 weeks compensation, I believe, is 7.7 years. So it's not nothing to shake a stick at, but it's still 7.7 years in the life of a 40-year-old is not a big chunk of their life. And after it's all said and done, what do you do next? Your comp is done. You're done. You have to figure out a way to move on with your life. So there is that cap. You don't get partial benefits for the rest of your life. It used to be that way back when things were good, but workers' comp has changed over the years, and they've implemented the cap. So back in the day, if you had a 50% permanent partial disability, you'd get a 50% rate of compensation for the rest of your life, and you didn't have to do a work search to maintain that. But the screws have been tightened, and we have to deal with them, which is why having somebody who understands the changes in the law, the current status of the law, and how to deal with the current law is so important. And it's hard to do on your own. It's easy to do with a lawyer who knows what they're doing. That's me. 212-406-8989. I see the questions are flowing, so we're going to get through all this and hit your questions. So we discussed the cap. There's a limit on how long you can collect your benefits. So that's the cap. And like I said, there have been more changes in recent years that are even more restrictive. Back when the cap was first implemented, okay, fine. If I have a 50% disability, I get 300 weeks of compensation. Well, I'm going to do everything I can to drag that case out as long as possible so that once that 50% cap hits, it's 300 weeks from that endpoint forward. So I could add time on. But there have been changes to the law. If you Google Workers' Compensation Law 15.3W, you're going to read about it. And 15.3W basically puts some limitations. If you are partially disabled after the 2.5-year anniversary of your accident, those weeks of compensation that you're partially disabled for, the carrier could take credit against your cap. So your 300 might become 250 or 200, depending on how long you've been getting compensation. So it's important to know what all that means and how you can deal with it, and manage your expectations and get a clear understanding of what your case is worth so you're not blindsided. Water break. What else? If you don't have permanent damage. So if you don't have a permanent injury, there's a pretty good chance that you get nothing. Where do we see this? Well, the people who have the soft tissue neck and back cases. Yeah, I got hurt. Yeah, my back is killing me. Yeah, my neck is killing me. Yeah, it even still hurts me to this day. But I was out of work for 6 months. I got treatment. I got good enough that I can go back to work after 6 months because Lord knows staying home on comp wasn't helping me. And I went back to work. And I'm back to my job. I'm earning the same amount that I was earning before my accident. I'm in a ton of pain, but guess what? For those non-scheduled cases, there's really not a lot left to do there. Your medical's open. You can get your treatment. God forbid your condition worsens. God forbid it worsens down the road. Your case is still there for you. But the value of any type of settlement is not there. And the value of litigating that case in front of a judge is really not there because there's we call it no compensable lost time. What happens in a case like that? The insurance company might throw you some money to close out the medical side of your case and just be done with everything, just so that knock on wood, God forbid, circumstance ever happens that you do come back and reopen the case because you go out of work. They might give you some money. It's not going to be something that's going to make you happy. They're giving you money just to purchase the uncertainty of a possibility that your case might reopen down the road. And people, and I don't blame a single one of them. They say, I'm not settling my case for that. I'm not settling my case for $5,000, $10,000, even $25,000. I have herniated discs in my back and I'm only going back to work because I really have to, but God forbid this gets worse and I go out. I want my case to be there for me and I want my medical to be there for me so I can try to get better. I don't blame them. If that's what you got to do, you go for it. So if there's no permanent damage, if there's no impairment, if there's no loss of wage earning capacity, like we discussed, there might not be a whole lot of money left. Low impairment rating. So, your doctor's going to give your impairment rating if you have a permanent partial disability and you haven't gone back to work. They're going to give their findings, and the insurance company is going to give their findings. And unfortunately, sometimes we see that they're completely incompatible, and sometimes we see decisions that come down that don't seem to make much sense. And some of the changes that have been made in the workers' compensation law, and this might anger some people out there, and if it does, I apologize. I still respect everybody in the business here and in the system. But back in the day, a back injury or a neck injury or neck and back injury used to be rated based upon a pretty rational numerical scale. The doctor would say, I believe this person has a 50% permanent partial disability. This person has a 70% permanent partial disability. The neck and the back combined give me a 75% permanent partial disability. That makes sense. 75% out of 100, that's pretty high. We call that a marked permanent partial disability. Makes sense. Well, they changed that. The medical treatment guidelines, the guidelines for determining impairment have now made it a letter grade system, which on its face seems like it makes sense. Okay, A through Z. Instead of 1 through 100, it's A through Z. Okay, well, if you have a W, that's pretty high. Well, not every scale and every chart and every, there's different charts and different scales that have to be used based upon the different injuries. So it's not just A to Z for a neck injury. There's one scale for a soft tissue non-surgical neck. Then there's a soft tissue surgical neck. Then there's the fractures, and then there's this and that. There's different. It's gotten very confusing. And not every scale is an A to Z scale. None of them are that I know of. They are A to G. So G is now your Z. And how is G 100% if it doesn't, it's confusing. And what that does is it throws a lot of confusion into the system, and it allows for a lot of interpretation and a lot of outside influence over what an F really means for a back. Back in the day, 60% meant 60%, and now we're taking an F injury, and then the judge has to convert that to what they think that number would be. And why is an F worth a 50% on one day and an 80% on the next day, and then a 30% one day after that? It doesn't make much sense. And then they have to factor in your vocational background, something which I do like, because your vocational background plays a major role, and your life is an important thing. You might have a 20% permanent disability to your back, but you might also be fighting cancer right now, and you're not really so able to go out there and look for work because you have the circumstances of your life are preventing it. So it's nice that we can look at a person as a whole in determining what their wage earning capacity is. It's nice that we can look and take two, and I do this. Those of you that are my clients will know this one. When I do this, I say, you take two people, Harvard educated, speak 7 languages, NASA astrophysicist, and you take this guy who has the exact same spinal injury, who cannot read, write, or barely speak, doesn't know how to spell his own name, and all he did was sweep floors his whole life. Well, this guy's vocational capabilities are going to take his level of disability and bring it down. It's going to be easier for this guy with a 50% back injury to find jobs in the future. This guy with the same 50% permanent injury to his back is going to have a much harder time finding work in the future. So maybe his 50% is an 80% or a 90% or 100%, which is what I would argue for, versus this guy who's 50% is a 40 or a 30 or 25. So vocational background does come into it, and that's something I do like about the system. So yeah, it's not all hatred. I love it all. But those are things that need to be considered. Impairment rating. Surgery. People say, well, I had surgery. My case is worth $100,000. I had surgery. I had surgery. I had surgery. I had surgery. Did you know I had surgery? The ones who had surgery, it's like people who have an air fryer. They love telling you about it. I know you had surgery. I'm your lawyer. I know you had surgery. I have all of your medical records in front of me. I know things about you that you probably don't know. Okay. I know when you quit smoking. I know everything about you because it's all laid out in your medical records in front of me. So I know that you had surgery, and I know you love your air fryer. I get it. Doesn't automatically mean that your case is worth more. What's the deal with surgery? Well, surgeries show that you had a significant injury. They don't do surgery on stub toes and soft tissue, easy, light, non-disabling accidents and injuries. Surgery is done in significant situations with significant injuries. So yes, surgery kind of proves that you have a bad injury. But what's the purpose of surgery? It's to help you get better. So, there's two sides to that coin that people often lose sight of. But yes, surgery does, as an initial indicator, show that you have a significant injury. But you got to keep in mind that surgery was there to help you out as well. So just because you had it doesn't mean that you are, on death's doorstep with your injuries, and therefore your case is worth $8 trillion. Surgery is there to help. You don't get paid if you return. So we discussed that earlier. Going back to work on a non-scheduled case, if you're earning the same amount or more, your case might not be worth a whole heck of a lot or anything at all. If you go back to work on a non-scheduled case, those head, neck, and back cases, if you go back to work and you can't work your full capability and you're earning less, you could have a reduced earnings claim, and now the value does go up. Again, things that you need to always speak to your lawyer about. Pretty regularly, you talk to people like, I went back to work. I went back to work. I went back to work. And all of a sudden you find out they went back to work. They used to work 9 to 5, Monday through Friday. Oh yeah, I'm only working 9 to 12, Monday, Wednesday, Friday. So you went back to work 9 hours a week to a job you're working 40 hours at. You didn't want to tell me that? Oh, you said if I go back to work, I thought you went back to work. Yeah, that's a big deal. Make sure you talk to your lawyer about that. You might be entitled to reduced earnings. And those are questions we see pop up all the time in the comment sections on the videos. Yeah, you might be entitled to reduced earnings. That's why you need a lawyer who knows and knows how to find that information and pull it out of you and then use it. Reduced earnings, it's a big deal. Don't let it go. What else? Schedule loss of use awards. Another big one. Met a new client yesterday, great guy. He says he found me on TikTok. Welcome to the family. We're going to take good care of you. But what did we discuss? And not only that, I had a discussion with another client this morning. Schedule loss of use. You get hurt. You're out of work for a couple months, couple weeks, whatever it is, and workers' comp is paying you those benefits. They're going to take credit for those payments for your lost time from the final settlement, from the final schedule loss of use award in your case. So if you're out of work for 10 weeks and you're getting $1,000 a week, that's $10,000. If your schedule to your shoulder is worth $50,000 and you already got 10, you're going to get $40,000. If you've been out of work for 3 years and they've paid you $140,000 in lost time benefits and your schedule is only worth $100,000, your schedule's not worth anything. Got to keep that in mind. What I always tell people, as soon as you're able to go back to work with an injury like that, you go back, because then the credits stop. They stop paying you comp for your lost time because you're not losing time. You're back onto making your salary. You're working, you're making money, and there's less credit taken out of your schedule at the end. So you actually put a few more dollars in your pocket that way. Excuse me. So that's the schedule loss aspect of things. Unanticipated offsets like Social Security, pensions, unemployment. Yes, there are offsets. Social Security offsets, not workers' comp, but yes, every once in a while with pensions and certain aspects, there are certain things that could have an impact on your workers' compensation case. State to state, it changes, so make sure you talk to your lawyer about that. But other things like child support. Child support's the big one. Child support, taxes, spousal maintenance, unpaid attorney's fees, things that are lienable. Here in New York State, child support's the biggie. If you are behind on child support, it's going to be taken out of your settlement before anything happens, and then you could deal with the aftermath. So if you are settling your case for $100,000, great. And let's say your lawyer is going to take a fee of $13,500 from that $100,000 settlement. Fantastic. And you agreed, and you sign the papers, and you go to court, and you sit down in front of the judge, and the judge is going to say, you're settling your case for $100,000. Your attorney is going to get $13,500. By the way, you owe $70,000 in child support, in back child support. That's going. You could turn around and say, I'm withdrawing from the agreement. I don't want to settle my case anymore. But if you do, even your weekly benefits, they're going to be hit. But if you go through with that settlement, they're going to take that money and pay child support, spousal maintenance, alimony, taxes. If you owe money to people who have more power than you do, aka the government, they are going to take their money. It's like Chris Rock said, you don't pay taxes, they take taxes. And he is right. I always love that one. You don't pay taxes. So yeah, they're going to take money out of your settlement and pay. And next thing you know, the value of your case just went down. What happened? We want to make sure you know what's going on. You don't get 100% of your case value in your settlement. And what does that mean? When I hear value, I think of what the case is worth at the time that we're settling it. But people say, well, I'm entitled to $500 a week for 300 weeks. That's my PPD. That's $150,000. Give me my $150,000. No. If the insurance company owes you $500 a week over 300 weeks, over 6.73 years, I believe, they're going to pay it out over that time. If they're going to give you a lump sum check right now, they are not giving you all of it. They're going to give you the present dollar value, plus they're going to take more credit for certain deductions and discounts. And of course, they're going to try to give you as little as possible, but certainly they're not going to give you the full dollar for dollar value. Why? Because a dollar today is worth more than a dollar tomorrow. At the most basic level, present value of money, inflation. I had the discussion today with a client where I said, we laid it all out, and I said, and I'm just going to make up the numbers here, the full value of your cap over the term is $175,000, but they're offering you $135,000 today. Would you rather have $425 per week over the next 300 and something weeks, or $135,000 today? And she's like, I don't know. Well, let's try doing it this way. How much is a dozen eggs right now? Oh, a dozen eggs right now. Jesus, it's like $6. Okay. How much was a dozen eggs 5 years ago? Oh my God, 5 years ago, you can get a dozen eggs for like 99 cents or $1.25. Okay. If eggs have gone from $1.25 to $6 in 5 years, what do you think they're going to cost 5 years from now? That $425 check you're getting today is going to buy a lot less eggs 5 years from now. So if you could cash in on it today, when the money's got value and you can invest it and do something with it, you go for it. That's my economic background. That's all I got. You waited too long to settle, and your case is worth less as a result. And we see this happen in a couple different ways. Some insurance companies will give you their valuation and make their offer. They'll say, we're giving you $125,000. And you go, I think that's low. And then your client takes 6 months to think it over. And then this, that, and the other thing happens. And then finally, a year goes by and they say, all right, I'll take it. And then you tell the insurance company, all right, the client will take the 125. And they say, no, you've been getting comp for the last year. Even if it's a pretty low rate, we're going to take credit for the last year of payments we've made to you and knock that off the 125. We'll give you 100. Yeah, all of a sudden you waited too long and your case is worth less. When that really happens is when you have been classified and you're on that schedule, that cap, that running award. Your cap gets eaten up with each passing week, and the more you wait, the more that gets eaten up and the more the value goes down. Sometimes you could fight the insurance company when it's a matter of them just digging their heels in, and you could say, look, you don't want to settle, don't settle. You'll be on the hook for a long time, or he's going to go for surgery, or something else pops up. But if you're classified and you're on that schedule, good night, everybody. Everyone's leaving. Bye. If you're on a schedule of awards, well, then, yeah, you don't have much say there because it is what it is. It be what it be. So it's for these reasons, folks. And these are the biggies. But this is why it's so important that you get a lawyer who you trust, who knows how to get you the most amount of money possible, who can get around these perils and pitfalls, as we call them. Nationwide statistics, we did some research here, show that on the average, injured workers who have a workers' compensation attorney end up with 30% more benefits than they otherwise would have gotten if they don't have an attorney. And, we pulled the statistics there, we did the research, and I'm not tooting my own horn here, but, that's almost like saying nationwide statistics have shown that people who have their car fixed by a mechanic have better running cars than those who do it themselves. It doesn't mean you can't do it yourself, and you probably would do that. It doesn't automatically mean you would do a crappy job of changing your timing belt, but you would rather have the guy do it who has the experience and the know-how. So that statistic, the 30% more benefits, that's after paying lawyers' fees, which come out of your benefits. And you only have to pay if we actually get you money. So that's even after considering your fees. So it's important. And as an attorney, excuse me, as a workers' comp attorney here in New York, the consultations are free. And it's like I explained to a client yesterday. You hire a lawyer, even in a circumstance where the insurance company is paying your benefits and they're paying the right amount of benefits, they're giving you the treatment that you need, they're doing everything that you need them to do. And you go and hire, well, I don't need a lawyer. Now they're doing everything that I need them to do. They're paying me on time. They're paying me the right amount. They are approving all my medical. Why would I need a lawyer right now? Well, if and when the poop hits the fan, if you hire a lawyer, we're a phone call away. Hey, I didn't get a check. Can you find out what the heck is going on? Hey, all of a sudden I went to see their doctor and my check got cut in half, got even more than that. What do I do? Well, if you have a lawyer in your case already, we're in the case. We open up the file, take a look at what's going on. We probably know about it already, and we can make some phone calls. And if we can't work it out, we can request a hearing. Whereas if you don't have an attorney, now you either have to A, try to figure it out on your own, or B, you're scrambling to find a lawyer. And if, let's just say you come to my office and you say, look, I got hurt in April of 2025. They've been paying me all along. And now on September 10th, I got my check and it's a third of what I've been getting. Well, I don't know automatically what happened here. I could try to figure it out given your paperwork, but I need to get into your file. I need to take a look at the whole file. I need to reach out to the adjuster. I need to get a hearing requested protectively so we can start that process, because that could take a couple of weeks. It's going to take me a week or two to get into your file to begin with. But if I'm already there, a phone call away, and it doesn't cost you anything unless and until we have to get involved, why would you not want to have that protection? So that's my horn tooting that I'm going to give you. Now, let's get to some questions. First, I need a beverage. Pardon me. Does anybody want me to sing a song? There it is. Okay. Let's start at the top of the top. Robin always has nice questions for me. Hi. I don't know where this cough came from. I was feeling A-okay. I was told when I signed a Section 32, indemnity only. What's indemnity only, folks? Medical stays open. That I am allowed 10 maintenance PT visits a year and don't have to ask workers' compensation. But now they say I have to go through workers' comp. Is that correct? Well, I'm assuming that you're asking a New York-based question for a New York-based case. So when you say maintenance care usually comes in a circumstance where there has been a finding of a permanent partial disability. And generally speaking, that is correct. If your doctor is asking for more or different treatment than is otherwise permitted in the guidelines, he does have to request a PAR. The doctor would know exactly what is permitted under the medical treatment guidelines. Maintenance care is one of those things. So you may or may not need specific authorization. It depends on what the doctors are specifically requesting. So sometimes PT is not just as simple as PT. There's OT and there's, water therapy and all that kind of stuff. But that's really a question for your doctor more than anything else. But maintenance care is permitted. Ms. B chimed in, said if it's a workers' comp injury, all treatment goes through workers' comp department to get approved. If workers' comp does not approve, then they won't pay for it. That's mostly true, but not entirely true. We fight with them and we get it paid. But if it's treatment that requires authorization and if it's treatment that deviates from the guidelines, then yes, approval is needed. If it's treatment that's in accordance with the medical treatment guidelines, then approval is not needed. So, and that could be for something like surgery. If a person has a torn meniscus in their knee and the guidelines say get 12 visits of physical therapy, then get an MRI, then get what's that stuff called? An orthovisc injection, and then get 6 more PTs. And then if you're still symptomatic and blah, 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 go for surgery. If the doctor has followed that guideline to the point of surgery, they don't need authorization. If that's where they're at, that's where they're at. They can go ahead and do it without authorization. A lot of doctors still kind of give us a hard time at that point because they want to make sure they get paid. Well, what if I do the surgery? They don't pay me. Well, bro, that's your problem. No, we'll make sure that if you follow the guidelines and you laid it out, that we're going to show that to the judge. And listen, the judges know it also, and they usually are there to help and get you paid, get your doctor paid. This is why Ms. B says you should get a lawyer to make sure you get the treatment you need. Rex will answer once he gets to answer your. Rex will answer once he gets on to answer questions. Yes, Ms. B, thank you. How are we doing on the likes? Robin, I was diagnosed with complex regional pain. So every time you guys mention complex regional pain, CRPS, I always do the acronyms for the 2 synonymous disabilities and their names. So CRPS is complex regional pain syndrome, also known as RSD, reflex sympathetic dystrophy, and I don't like it. It's a bad one. But she has CRPS of the right foot and right arm. My back, neck, and left foot is on the claim. Medical is open. One pain doctor said low back without radiculopathy, but the neurosurgeon says radiculopathy. What happens next? I don't know. I'm not a doctor. I don't know what you're actually asking me. I don't know what you're specifically asking me. I sure wish I knew about Rex when I got hurt. The COVID day. That was the year 2 of COVID. Who is your lawyer? Talk to your lawyer. Those are questions for your lawyer. I get those questions from my clients all the time. Hey, this is where I'm at, and I'm a little frantic. Can you walk me through this a little bit? I have stinging, burning, tingling all of my body. Yeah, complex regional pain syndrome. And I'm not a doctor. I'm not diagnosing that's what it's causing. Stinging, burning, tingling all over your body, chest, neck, and face. But it could be, and it's a horrible thing. I'm sorry if you are going through that. The AE low key. He low key wishes he could switch to my attorney. Well, you're not bound by anything, my friend, but I'm certainly not a proponent of attorney switching unless you really need to. Make sure, give your lawyer a chance, sit down with them, get explanations, get an understanding of the things that are confusing you. And if you're still having problems, you can, and you're not seeing eye to eye, then that's the time to potentially move. Ms. B. Ms. B says you can switch attorneys if it's beneficial. And she also says, make sure you hit the like button under Rex's pick. Is it here? Or is it here? I don't see it on mine. Here. Hit it down there. Courtney. What does that say? That's just your name. In Missouri, 2 tears in the rotator cuff, 1 tear is high grade. I'm refusing surgery. Will my settlement be much lower? I don't know Missouri law. So in New York, we get that question a lot. Some people are afraid of surgery, and I get it. And they'll say, look, my doctor really wants to recommend surgery, and I don't want to do it. Is that going to hurt me, hurt my case? Well, is it going to hurt you? Yeah, it might hurt you physically. It might be a problem for you medically, and that's between you and your doctor. But what does it mean with respect to your case value? Well, we're going to use the shoulder as an example. If you've gotten hurt and you've gone through all the treatment that could possibly be administered to a shoulder injury, a high-grade rotator cuff tear, so on and so forth, and the last option is surgery, and you're choosing not to have surgery and there's nothing else, well, then it sounds like you might have reached maximum medical improvement because that surgical option is not an option. And the doctor's going to assess you for permanent disability. And the insurance company might tear into you and your doctor a little bit and say, well, if you would have had surgery, you'd be all better. Well, you can't force somebody to have surgery. So it could decrease. And it's like we discussed with surgery earlier. Surgery is indicative of a significant injury, but surgery is also there to help a significant injury. So there's 2 sides to that coin. Not having a surgery for a significant injury might lead to the conclusion that maybe that injury is not as significant as we all thought. But then again, the surgery that was recommended didn't give you the improvement that it's supposed to give you, so you might have a higher schedule loss of use because of that. It's an interesting conundrum, and we're always sure to argue the opposite side whenever it's brought up. I hope you have a lawyer, and you can ask him that question, and he can give you a more honest answer based on Missouri law, because I don't know Missouri law. I think this is an old one. Only 3 likes. Puh. Callahan, Big Tom Callahan's son. Hello, Rex. Do I have to contact the Workers' Compensation Board if my attorney ignores my calls and my updates? Thanks. No. I hate hearing about this stuff. Call your lawyer. Get an understanding. Don't nudge your lawyer. Nudge is a get an explanation. Get an understanding. And if you're really not getting back, if they're not getting back to you, send your attorney an email. Make an appointment and go see them. And I see you also want me to talk about third-party cases in my next video. And that's a great idea. We are going to, I think we might do a series of third-party cases and talk about the biggies. What are the biggies? The car accidents, the construction sites, the slips and falls. And maybe we could do a little symposium on each one. One week we could do the slip and falls. One week we could do the car accidents. One week we can do the construction sites. 1 week we could do some miscellaneous products liability and things like that. Sai, let's kick that idea around. I don't know how this became my hand gesture for kicking an idea around, but we just invented something. Leon Korn, I'm in New York. I got reared. I think you got rear-ended while working. I don't want to think what else that could have been. Can I do workers' comp and no fault? No. Workers' comp comes first. So if you are working and you get hurt on the job, workers' compensation insurance is there generally, not in every circumstance, but workers' compensation is there to pay for your benefits. If you're driving in a car and you have a motor vehicle accident, no fault is there to, you good? Catherine's coming in with something hot. What? He died? Wow. Anyway, excuse me. So if you are injured in a motor vehicle accident, you can you file for no fault. What happens if you're injured in a motor vehicle accident while working? What do? Well, who pays the bills? Workers' comp pays the bills. So workers' comp comes first. Sometimes in certain circumstances, I just had this explanation the other day. Take your Uber driver, for instance. Guy drives an Uber. He uses his personal car for work, for driving for Uber. He has passengers. He does pickups and drop-offs for Uber. And then at the end of his day, he goes and picks up his wife from work. He shuts his app off and he's driving his wife home from work, and they get rear-ended. Sounds like no fault to me, not comp. He's not working. Well, a lot of times no fault's going to say, well, are we really sure? Was his app off? Well, what no fault does is they deny the case. They say, we're denying it. We're going to say that you were working. And unless and until you get a determination from workers' comp that you were or were not working, we're not touching this. So then we have to go in front of the workers' comp board, and we have a trial, and the judge says, and we handle like any other trial. Sir, what were you doing at the time? I was driving my car. Who do you work for? I work for Uber. Was your app on or off? My app was off. Did you have a passenger in the car? Sure did. Oh, who was it? It was my wife. I picked her up from work. Well, doesn't sound like you were working. I don't think I was, but they want me to come here, and here I am. And your workers' comp gets disallowed, and then you go to no fault, and then no fault picks up. So that's how that works. The eggshell law, the thin skull rule, the eggshell skull rule. I love it. Robin, if I could give you 5 gold stars, I would do it. If I can give you 10, I would do it. Why? Because I'm a nerd. Deep down under this handsome face and chiseled body, I'm a nerd. I'm joking. Why am I a nerd? Because I love these little law school tidbits that I've stuck with over the years. And maybe I'll tell you a little story, but I've used this in court. The thin skull rule, you take your victims as you find them. The thin skull rule, the eggshell skull rule, was a case from like way back in, however hundreds of years ago, where, and I forget the specific circumstances, but 2 kids were messing around on a playground. One kid like threw a ball or like tackled another kid or bumped another kid. So there was some roughhousing, and the victim, wound up suffering this really horrific brain injury. Why? Because he had a condition where he had he had a thin skull. And the argument is, well, it's not my fault that this kid had a thin skull. Who was I to ever expect that the kid would have a thin skull and he would suffer this disproportionately huge disability as a result of my relatively minor negligence? We were playing ball and I was trying to be funny and I threw the ball at him. I was just messing around. I didn't think that this kid's head would cave in. And that's a valid argument, right? You don't expect it. The reasonable person standard. A reasonable person wouldn't expect a person's head to cave in from a relatively minor horseplay, child's play incident, right? Right. Well, what does the thin skull rule say? You take your victims as you find them. It's the olden times version of FAFO. Right? You know what I'm saying? Fuck around and find out. If you're going to do something that's even remotely negligent, that's minimally negligent, that's whatever negligent, and somebody's head caves in as a result, you effed around and you found out, right? Right. It's almost like the felony murder rule. If you're out there and you're going to rob a gas station, and at some point during the hullabaloo of you robbing a gas station, something happens and somebody dies, even if you didn't intend to kill anybody, you could be charged with felony murder. It could be prosecuted as a murder. So the eggshell skull rule, the thin skull rule, they're interchangeable. Look it up. Google it. It's actually a really cool old case. And, you know, I was trying to be funny and I threw the ball at him. You know, I was just messing around. I didn't think that this kid's head would cave in from a relatively minor horseplay, child's play incident. Yeah, I've used it because these are like those little these are those buzz terms that you remember from law school. And the funny story I had was another one that we have is unclean hands. Look up the unclean hands doctrine. You're not supposed to come to court asking the court for help with unclean hands. If you've done something wrong, you shouldn't be asking to right the wrong of another. That's the unclean hands doctrine. And years and years and years ago, and this is outside the workers' compensation forum, I was involved in a case and multiple defendants, and I represented a defendant, and I was fresh out of law school. And there was 3 or 4 or 5 defendants, I don't remember. And we had a trial. And I remember the plaintiff that was suing all these defendants wasn't really a good guy. And we go in there and we're in court and we're giving our opening arguments. And I'm fresh out of law school. I had hair in the spot here where I no longer have hair. My glasses were not as strong as they currently are. I was a young buck, and we go in there. The plaintiff gives his opening, and defendant attorney number 1 gives his opening, and defendant attorney number 2 gives his opening, and they were all being sued for the same thing. So how much can my opening argument really change from what has already been said? Finally, it's my turn, and I go up there in my Joseph A. Banks suit that fit a little funny because it was one of the new ones, and I'm sweating because I'm in front of a real judge in a real court, and I'm young, and I have no idea what's going on. I actually had a very good idea what's going on, but I'm just scared shitless. And that's really what it comes down to. I was nervous. My hands were gross and sweaty. And it's my turn. And I go up there, and it's like, Judge, good afternoon, Judge. May it please the court. Stuttering like an idiot. And I said, basically, Judge, the other attorneys laid it out really, really well. They my argument, is the same as their argument. I didn't even have the nerve to use words like I concur with them and I join in their argument, things that you would say now. And I said, Judge, they kind of laid it out, and I don't have much to add except, the unclean hands doctrine applies, and the plaintiff really shouldn't be asking for relief from the court if he comes to the court with unclean hands. And the judge looked at me, and he laid back in his chair, and he said, "That's awesome." He goes, "You're fresh out of law school, and you nailed it." He goes, "I like that. I didn't even think about that." And with that, he said, "Let's go have some conferences." And he stopped the trial. He called the plaintiff back into his chambers. They had a little chit chat. It got loud. It was nice. And then he called us back there, and we had a little chit chat, and it was much more amicable. And next thing you know, we had settled the case. So yes, eggshell skull rule, unclean hands. I love it. That, folks, I'm a happy guy right now. I'm such a loser, but whatever. You understand. And Miss B says she's on it. Mr. Marte, hope all is well. Let's go Mets. Man, they suck. After our conversation last week, my case has 6.5 years in. I recently got my lower back surgery. A new IME was booked with another insurance company. The TPA educated me. Is that normal? Maybe. I need to know more about your situation. Is that a Porsche you got there? That's a nice Porsche. But it could be. I mean, you're 6.5 years in. It's time for that case to potentially start winding down, and I would need more information. But I know you have an attorney on it. Ask him to give you a breakdown because he's a good guy. The Clydesdale. I've had 2 operations in Maine, one in New Hampshire and one in Vermont, and boy, are my legs killing me. My doctor never listened to me about saying my scapula was torn. I lost my job, and the insurance wants to settle so quickly, and I want to go to Boston and fix my arm. Now, again, I don't know Maine workers' compensation law. And it's funny because we have a client here who has a New York case and had surgery here and is recuperating in Boston. So Boston must have something in the it must be the T in the water in Boston Harbor that allows people to heal better. But I don't know if that's permissible under Maine law. Do you have a lawyer? Question number 1. And have you asked your lawyer? Question number 2. And if you need you need to consult with an attorney. Call me. I'll see if I can help find you somebody. Malpractice, that's a possibility as well. I could try to get you hooked up with somebody with that as well if you want to give me a call. To determine if an attorney is billing correctly, is there a breakdown, or can I ask the legal board? Are you talking about workers' comp or in general? In workers' compensation, we don't. It's not billable hours. If it was, there's cases that it's not billable hours. It's a quasi contingency fee here in New York State. It's based upon how much money we get for you. So billing, and we don't get expenses. So it's not a matter of billing. It's we got you $10,000 in retroactive awards. The judge is going to award a $1,500 fee. They're going to send us a check for $1,500. You're going to get a check for $8,500. There's really no billing per se. In other aspects of law, if you have a contract dispute, if you have a civil action, sometimes depending on the type of case, then billable hours are a thing. And yes, there are ways to, there's checks and balances there. So yeah. It's 5:24. I'm going to go for another 6 minutes. T. Robinson, yes, you can call me tomorrow, or I can call you tomorrow. See that? But I got 6 minutes because I gotta catch a train. If you found this valuable, don't forget to hit the like. Don't forget to like. Help me out. Help me help you. Oh my God, you guys brought me so many great questions, and I'm like, I gotta. Where'd you go? Mike Harms, Nevada, 2 surgeries, fusion laminectomy, and still have numbness in my leg. Getting $700 from workers' comp. Got an MMI rating of 40%. I don't know what a 40% in Nevada translates to, so it's hard to say. And I know you're thinking 200K. You're 52. You're a young dude. Can't do his old job. I can't provide an assessment on law that I just don't know. Call your lawyer. Please, please, please get an answer from them, get an explanation. Clydesdale from Maine is receiving $12.46 and change a week. He worked for 2 years in the office. Wasn't good at the office work. My doctor said I'm in no work capacity. Again, I need to know the law of your state, which I don't. I'm only licensed here in New York. New York questions, I got New York answers. So hit me with those. And if you're out of state and you need help finding a lawyer that can help you, please, 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 please ask me. I can help. I see Clydesdale has a bunch of questions here. Yeah, the harassment from his bosses, things like that. You know, I'm sure there's avenues to pursue those things in your particular state. There are here in New York, and we got to get you on board with the right people. King Geddes, I had an injury at work last 2 weeks. I did an MRI, and I have a grade 3 ACL2 flap tear, posterior horn of the medial meniscus. And the question is, I don't know. Clyde, there it is. It's sad when you get hurt at work and not what you go through, but they put you through sometimes just to be able to make ends meet, to get you through a time where you're freaking hurt. It's not even like you're dancing around and having a good time. You're home hurt. I get it. And that's why I do what I do, because it's bullshit. And I want to help people. I'm just going to zip through and just pull out a couple more questions here, only because I don't want to not. If a person, all right, Miss B was getting to something. How do you know if the case is better to settle now or wait till it settles later? Like if a person's still getting treatment, so sometimes, and it's like I said before, every case is different, and some cases are better, just because of the circumstances. Now is a good time, or then's going to be a good time, and every case is different. But generally speaking, I like to start that assessment before, just as we're approaching MMI, but not really there yet, because there's an idea of which way the evidence is pushing a case, but there's still some flexibility, uncertainty that you use to your advantage. And you can try to use that to sing us a song. By the way, I believe it was on, I don't know if it was like HBO Max or Netflix or Prime. And I'm a Long Island guy, and take this for what it's worth. And I know whatever. There's a Billy Joel, it's a 2-part documentary. Awesome. I enjoyed it. I recommend it. And I believe on Amazon Prime, there's like a 4-part Dale Earnhardt, just to show you the complexity of my interest. There's a Dale Earnhardt special on Amazon Prime. I think it was like 5 episodes, an hour each. Fantastic. It'll make you cry in the end. Oh my God. New York State IME gave me MMI for my shoulder as 29%, hip 20%, knee 15%, but I can't do make it decisions on my back. I can't. So leaving my back open, keeping treatment for I'm confused. The insurance company's trying to lower you, so it's probably because they're looking to pay you for your temporary disability and pay you for your permanent partial disability, non-schedule, if you're not working. And you should drink emergency 1,000 vitamin C, zinc. You're right. You're right. You're right. You're right. She's right. All right, folks. I need to catch a train. Passport Adventures, I'm so happy that you're happy, and I'm happy to help. Folks, if you like what you hear, hit the like button, subscribe. It gives me a sense of pride. Give them a sense of pride. Make it easier. Let the children play. Victoria, call. Did we touch base? I know you wanted to speak, and I wanted to make sure I answered your questions. I don't know if degenerative cases are worthless in Florida. I do know some very good lawyers in Florida. If you need help linking up with them, please let me know. How about be careful of the tree. That's, you know what? It's crazy out there. The Mets, man, I don't know what to say. They're going to make the playoffs, but we need to pick up the pace here. New York football, the Jets are a good, terrible team, and the Giants are a terrible, terrible team. Whatever about New York football. Hockey starting soon. You guys know I'm a hockey guy. Basketball is going to be picking up. So, we're shifting gears. The leaves are falling, and it's a beautiful thing. Please be safe out there. That's really number one. I'm happy to help people who are hurt and need help and are in a tough spot in their life, and I get it, and I'm happy to help. But step one is just don't get into this. Ms. B's yelling at me. Can a workers' comp claim be affected if the client also filed for an EEOC claim? Generally, quick answer, New York State, no. There's separate actions. Does it mean that there's certain things that can be that some they might do in retaliation? Well, if it's clear retaliation, that they're only hurting themselves. So, generally speaking, if you have a valid EEOC claim, go for it. With that, folks, you guys did great today. Great, and now it's been the theme that I can't answer. There was a time when I was a youngster in this world doing these videos that I would answer all the questions, and I'd be like, I wish I had some more questions that I can answer for people. And now I can't get to all the questions because you guys are so awesome. Another year with your advice on workers' comp. Another year, folks. It's like Chinese New Year. It comes at an awkward time, or the Jewish New Year comes in the middle of the year. We're not celebrating New Year just yet. We have a few more months, but I'm happy to help. And as always, folks. Hold on one moment. Hold on to one more day. How do I do this? I can't do that. Okay. You guys are the best. I will see you next week. Let's pick a time. We're going to go Wednesday, probably. Wednesday, probably Thursday, Wednesday, 4 p.m. YouTube live. I've been up since 3 a.m. today. My daughter was crying. I went in to see what was wrong, and daddy rules. Somehow I got roped into making sure she was okay, and I spent the rest of my evening in and out of sleep, getting kicked in the ribs. Because that's how they do it. But for some reason, I've been on a second wind since 10 a.m. and I've been flying high, loving it. The coffee helped. Next Wednesday, 4 p.m. is correct. 4 p.m., 4 to 5. And we got you, folks. So I'm fired up, and I'm fired up for next week. We're going to do it. We're going to do it well. Sai and I are going to come up with a wonderful topic. It's gonna blow your hair back. You're gonna be amazed. Thank you for everything this week, folks. Great questions. Awesome questions. I didn't give it enough gold stars. I got caught up in the thin skull rule. But we got you. We got great questions. I want to thank everybody, and I'll see you all next week. Be safe. Be happy. Let's go Mets.